welcome to Project HR, a podcast dedicated to building better workplaces. I'm your host, Jennifer Oraqua, COO of Projections, and today we're going to be talking about conflict. There are few controversies that can be more damaging to a business than a dispute with an employee. And if that employee happens to be a key executive, the impact of that dispute can be even worse. One study even claimed that U.S. companies face a nearly 12% chance of being hit with an employment lawsuit, and that those lawsuits result in defense and settlement costs of, on average, about $125,000 per case. So clearly, the best scenario would be to avoid these kinds of disputes altogether. But when that doesn't happen, companies often turn to arbitration or mediation to help resolve those disputes and mitigate their impact. That's why we've asked Ross Runkel to join us for this episode. Ross has spent the better part of his career serving as an independent labor and employment arbitrator and mediator, and we are thrilled to have him here with us today. Thanks so much for joining us on Project HR today, Ross.
Thank you. It's a pleasure.
So I wanted to get right to it. When we talk about disputes between employees and their employers, what kind of disputes are we talking about?
The possible kinds of disputes are really endless. At one extreme, you have a person who's been fired and thinks that was illegal. At the other extreme, you have your day-to-day things like somebody wants to work overtime, somebody else wants not to work overtime, and then you have all kinds of things in between, people claiming sexual harassment or racial harassment, employee didn't get a promotion or a transfer, endless. And remember, these disputes can also involve independent contractors as well as employees.
Interesting. So let's walk our listeners through a typical response for a company in a dispute. So an employee or a contractor, like you said, files a complaint. What happens next?
Depends on what you mean by a complaint. Usually, a dispute is resolved by one-to-one discussion, just direct negotiation between, say, the employee and the supervisor or manager, and it doesn't get any farther than that. If it gets farther than that, in the unionized environment, you'll have a collective agreement that provides a formal process. Without a union, the company usually has some sort of internal complaint system, and that varies all over the map in terms of how that's done. Maybe the employee goes to a supervisor or a manager, or maybe they go directly to human resources. If it involves sex discrimination or race discrimination, a lot of companies have very formal policies targeted just for those kinds of situations.
Sure.
And of course, if it's an external complaint, you're really talking about a lawsuit or an arbitration.
So, ideally, you want those internal efforts to take care of things. But say like that first step that you talked about, where they try and get that face-to-face, with the supervisor and try and resolve it internally. Do most companies have an internal dispute resolution process, something like you said, a little more formal?
Typically depends on the size of the company. Small companies usually don't. Large companies, the larger the company, the more elaborate
Hmm.
the process is, the more detailed, the more it is known to everybody. So everybody knows exactly where they should go, who they should talk to, and what's going to happen once that happens.
Okay. So, how do companies typically communicate that? Is that something that's in the employee handbook, or how do they talk about what their dispute resolution process is?
It's almost always in the handbook, which might be paper or might be on a website.
So, Ross, I've always heard that there are different types of dispute resolution, ranging from lots of control over the situation to zero control over the situation. Can you talk about that a little bit?
Sure. Let me talk about four. Litigation we're familiar with. You have a judge and a jury, lots of formalities, lots of rules, appeals to higher courts. Arbitration is similar to litigation. The difference is it's not in the government system. The arbitrator is like a private judge, so there's no jury. The arbitrator has a hearing, makes a decision. That decision is final and it's binding legally on the parties, and there's basically no appeal from that. Mediation, very different, because the mediator doesn't have any authority to make a decision. The mediator's job is to come in and help the parties to negotiate themselves to reach their own agreement, something that the parties themselves want to do instead of like the arbitrator would tell them what to do. The mediator doesn't do that.
Hmm.
And then, of course, negotiation, which is what resolves most disputes, It's just two people face to face trying to work out a resolution. These are all voluntary and private processes except for litigation.
So, can a company basically mandate arbitration? And if they can, how does that work?
What people call mandatory arbitration, keeping in mind that arbitration is a voluntary process, but what happens is that an employee will sign an agreement, maybe when they're hired or later on, an agreement to arbitrate disputes that might arise in the future. And what the people in the business call it is a pre-dispute arbitration agreement. So then if a dispute arises later on, a court's going to enforce that agreement to arbitrate. So at that point, the arbitration actually is mandatory. But it's
Mm.
mandatory only because the employee originally agreed to it.
Right, right. Right out of the gate. So we talked about at the very beginning of the program. We talked about that litigation is probably the most familiar type of dispute resolution, but there's some compelling reasons for companies to avoid it. Can you talk a little bit about why we would want to avoid litigation?
Lots of reasons. It's
Hmm.
very complicated. You have motions and depositions and written interrogatories and requests for production. You have to hire a lawyer in order to go into the courtroom. It's a very lengthy process. It can go on literally for years. Companies typically do not like to have juries because they're always worried about what's called the runaway jury that will issue a huge money award to the plaintiff. And then you have appeals. Most states have two appellate courts, an intermediate court and a Supreme Court. So you have the possibility of two appeals. And all of this is a huge drain on emotions and time and energy, and it's really quite exhausting, let alone the question of the publicity that can come out of litigation.
So obviously, it's a very expensive proposition as well. So
It'll be expensive. I think you mentioned 100 and some thousand
yes,
dollars.
yes. All right, Ross, we're going to take a quick sponsorship break right now, but when we return, I want to talk about arbitration and mediation in more detail. So stay with us. Are you new to labor relations or working in HR and ta-da, now need labor relations skills? Today's sponsor, Union Proof Certification, has got you covered. Union Proof Certification is a comprehensive online course in labor relations that will help you get the knowledge you need to understand what's at stake, the language used by unions and attorneys, the resources available for assistance, and how you can turn a potentially frightening situation into a positive one. You can learn more at unionproof.com/certification. Learn years of labor relations knowledge at your own pace and earn 24 SHRM or HRCI credits at the same time. We're back on Project HR with Ross Runkel, an independent labor and employment arbitrator and mediator. Now, Ross, before the break, we discussed the difference between arbitration and mediation. So, how can company leaders know which is the right process for a particular dispute?
You know, if you have a situation where you're going to have an ongoing relationship, you have an employee that you know is going to be okay in the long run, and you're going to keep this relationship. You really want to use mediation because the mediator can help with the overall relationship as well as the absolute immediate dispute. The mediator can help you look for creative solutions rather than just a you're right, you're wrong answer. And so, sometimes that mediator is somebody from human resources
Hmm.
who comes in and mediates a dispute between an employee and a supervisor. So the key consideration is whether you want to turn the ultimate decision over to an outsider, an arbitrator, or do you want to work out an outcome that's agreeable to both sides? That's what a mediator will do.
So, you talked about potentially using somebody from the human resources department. Who are arbitrators and mediators typically? I mean, is it somebody that's called in from the outside? I'm sure there are exceptions to everything, but how are these people selected for a particular dispute?
Arbitrators are generally people that have a lot of experience with litigation. So those tend to be lawyers.
Mm.
or they're people with a lot of experience with labor relations. Mediators can be pretty much those same people, or they're people that are trained specifically in mediation who work with all sorts of cases. And one way to select an arbitrator is to go to an agency that keeps a panel of arbitrators. The American Arbitration Association,
Mm.
uh, JAMS, which is Judicial Arbitration Mediation Service, FMCS, which is a federal agency, and ask them to send out a list. And that agency will send out a list of, say, 7 people along with
Mhm.
their resumes. And then, fun game, the parties take turns crossing off names until only one is left. That's your arbitrator.
Got it.
Another way to do it is the parties can simply get together and agree they want a particular person. And some collective bargaining agreements simply contain a list of, say, 5 arbitrators that rotate for disputes. Hiring a mediator, it's much more common for the parties to simply agree that they want a particular mediator, but they can also go to an agency and get a list.
Hmm. Okay. So, in your experience, I mean, most of us have never kind of been involved in one of these. What does a typical mediation process look like?
Well, the mediator will come to you, or you sometimes the mediator has the mediator's own offices, and we'll start with everybody in a single room. And then typically there will be 2 other rooms, one for each side, where the people can meet separately. And the mediator's job now is going to be to listen to both sides and try to work toward a solution. The mediator's not going to impose a solution. And employees sometimes say, believe it or not, that this is the first time anyone really listened to them, even though somebody's been listening to them
Hmm.
before.
Sure.
And so the mediator will often carry one side's proposal from one room to the other and back and forth. And the mediator can help by explaining to the parties why one side's case is a little stronger than they thought or a little weaker than they thought. All of this is done in a confidential setting. Whatever is said or done in a mediation stays in mediation, and it can't be used later on if there's a
Mm.
litigation or arbitration.
So, how long does this process typically take in your experience? I mean, obviously, it's going to depend on the dispute and how heated it is and how many people are involved. But I mean, is this a day long process? Is this a month long process?
You're usually going to get a mediation done in one day or less, although sometimes that day lasts until 9 o'clock at night.
Yeah, I'll bet. That was an excellent explanation of what the mediation process looks like and what it feels like and how long it takes. How does a typical arbitration process differ from that mediation?
Well, arbitration is less formal than litigation, but it looks a lot like litigation. Everybody's going to meet in, say, a conference room with the arbitrator at one end of a table, parties on each side of the table. Each side is going to give an opening statement, produce witnesses, submit documents, and there might even be a court reporter. Then there will be closing arguments, or the parties will submit written briefs. The arbitrator goes home and writes up a decision, and that decision is going to be final and binding on the parties. And if the loser does not comply, the winner can go to court and get that decision reduced to a court judgment. Very different from mediation.
So, tell me a little bit about the difference between individual arbitration and a labor arbitration. What's the distinction there?
What we call labor arbitration is arbitration that arises out of a collective bargaining agreement. So you're only talking about employers that have unions and union contracts, and
Hmm.
those
Sure.
arbitrations involve whether or not the company has breached that contract.
Mm.
Individual arbitrations, really exactly what it sounds like. It's a case between the company and the individual rather than the union.
Mm.
And those cases can involve the employment contract, but also can involve statutes like Title VII and the Fair Labor Standards Act and the Age Act and so
Hmm.
on. So
Interesting.
you're actually arbitrating statutory disputes.
And in addition to whatever contract might be in place. So, within labor arbitration, there's more than one kind of arbitration as well. Is that right?
That's right. Most cases are what we call grievance arbitrations, which is you have an existing collective bargaining agreement, and the claim is that that agreement has been breached. The second kind is what we call interest arbitration, which is when the parties are negotiating for their next contract and they can't reach an agreement. An arbitrator comes in and tells them what that agreement is going to look like. A strange process, but it's often used with police and fire and prison guards
Hmm.
where they are not allowed to strike. And instead of striking in order to get what they want, an arbitrator tells them what they're going to have.
Fascinating. So, Ross, we're going to take some time out for another quick break, and we'll be right back after this. You're listening to the Project HR podcast. I'm your host, Jennifer Oraqua, and our guest today is Ross Runkel, an independent labor and employment arbitrator and mediator. Now we're back. There is one kind of arbitration we've yet to discuss, Ross. That's a class action arbitration. Can you tell our listeners a little bit about what that means?
Yes, class action arbitration is just like class action litigation. The main complainant represents a class of similar people. So the arbitrator's decision applies to all of them. And there's an interesting story here. There's a case where the drivers for a food delivery company, I won't name them, sued in a class action in court, claiming they were misclassified as contractors rather than
Mm-hmm.
classified as employees.
Mm-hmm.
And the company got the court to compel arbitration on a one-to-one basis. After that, over 10,000 of those workers filed individual arbitration cases with the American Arbitration Association. And the
Crazy.
AAA wanted the company to pay over $10 million in filing fees.
Wow.
Uh,
That's more expensive than litigation, I think.
my understanding is that case returned to court. Now, one
Okay.
thing employers are doing is that they're putting what's called a class action waiver into their arbitration agreements to make it clear that if the case does go to arbitration, it will not be a class action.
Interesting. Self-protection. We spoke earlier about mandatory arbitration. I'm sure you saw in 2019, the Google employees fought against mandatory arbitration and won. Do you think that's a sign that it's kind of on its way out?
I think it's not really a big trend. A lot of companies have decided that arbitration of sex and race discrimination cases should stop because it's such a private process and the public doesn't really get a chance to look at it. But I don't see a major trend toward eliminating what we call mandatory arbitration, although a lot of companies are just taking a second look at it to say, does this really make sense for us?
So, Ross, I don't want to end this interview without talking about the services that you provide as an arbitrator and a mediator. Can you tell us a little bit about that and how people can get in touch with you if they need to learn more?
Yes, I'm mostly an arbitrator, also a mediator. I work in the western part of the country, the West Coast states, Nevada, Colorado, Alaska, Montana, Idaho, and so on,
Okay.
not to leave out California.
Right.
You can simply Google my name. I have a website, rossrunkel.com. My
Hmm.
email is rossrunkel@gmail.com.
Yeah, I have to say I did exactly that. I Googled you and I found your video blog and I enjoyed it thoroughly. Can you talk a little bit about your video blog? Tell our listeners how long you've been doing it, what inspired it. I mean, clearly this is your passion, but and what all those videos are about.
Making videos just came to me out of the blue
Hmm.
about 3 years ago, and I have some personal videos, but the professional ones, I have a series called the Arbitration Boot Camp, which is a series of short videos on selecting an arbitrator, preparing for the
Hmm.
arbitration, opening statement, cross examination, and so on. I have a series called Notable Cases, which is employment law court decisions, and I think I'm up to number 54 now in that series.
Yeah.
And then I have a new series called Employment Law 101, which is a series on the basics of employment law. What's employment law at will? What about sex harassment and so on?
I have to say, it's one of the most fascinating employment law blogs I've ever seen, just because it's all video and it's fun to watch, and it's fun to watch your energy to see that come through on the video. I wanted to let our listeners know, too, that the links to Ross's website as well as his blog will be included in the episode companion for this episode. So be sure to sign up for it at projectionsinc.com/podcast. But we're not done yet, Ross. It's time for our lightning round question. These are questions we ask of every guest. Are you ready?
Yes, I am.
All right. So first question is a topic showdown. So in this episode, we've been talking about dispute resolution. In your opinion, which of the following resolutions, which have nothing to do with employment disputes, are the least reliable? The resolution of your TV screen or your most recent New Year's resolution?
Well, I don't watch TV, so it has to be my New Year's resolution.
Gotcha. Excellent. We watch a lot of TV, so I'd be up in the air on that one. So what's the best book that you've read recently?
A Gentleman in Moscow.
Yeah, excellent. Fiction. Do you read nonfiction as well?
Rarely.
All right. So tell me, what's your favorite thing about working as an arbitrator and a mediator?
It's really seeing how things happen in different workplaces. You know, I go to police, paper mills, grocery stores, silver mines, and they're all different. It's very interesting.
Yeah, I bet. So tell me, what's the best piece of advice you've ever been given?
At the beginning of my career, I was told to decide each case as if it's the last case I will ever have. Perfect advice.
That's a heavy weight to carry. All right, so finally, our last question. Tell me who or what inspires you?
Young people, fresh ideas. They're not locked into the way everything's always been. They're open to change. Yeah, give me young people.
Me too. Love that. Love that. Thanks so much for joining me today on this week's episode of Project HR, Ross. Thanks to our listeners, and as always, this is your reminder to grab the companion guide for this episode at projectionsinc.com/podcast. I also wanted to let you in on a little something we've got coming up later this fall. In November, Project HR will celebrate its first year anniversary, and we are planning some fun stuff to mark that milestone. So keep checking in with us for more on that. Finally, you can make sure you never miss an episode of Project HR by subscribing to the podcast. And if you're feeling it, drop us a line, leave us a review, or simply rate us 5 stars wherever you get your content. That's it from me for now. Let's make it a great day at work.